Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to Legal Ease, the show that translates legalese into English. I'm your host, Yumna Bhana. Now, marriage is a very exciting and also a very nerve-wracking time in a person's life. And the weeks and the days leading up to a wedding are filled with planning, organizing, and great festivities. But it's also a time when a couple has to make very important decisions that will impact on their future. And a crucial decision that a couple should be looking at when preparing for marriage is what type of marriage they will enter into, and if it's a civil marriage, what marital regime will apply to that marriage. Couples often find it difficult to make strong decisions at a time when they're entering into a marriage, but the importance of this decision cannot be overemphasized. The sound decisions need to be made at the outset of the marriage, because in particular they will have an impact on what happens to the estate of the couple, that is the assets and the liabilities, in the event of the marriage being dissolved or upon the death of one of the spouses. For today's show, we'll be looking at South African civil marriages, and we'll also be touching on the status of Islamic marriages in South Africa. With me in studio to discuss these issues, I've got Mr. Mahmood Mia. Mahmood, assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to the show.
Wa alaikum assalam wa rahmatullahi wa barakatuh. Thank you for having me on the show.
Before we launch into our discussion, let me give you a little bit of background about Mahmood. Mahmood has his own practice, Mahmood Mia Attorneys. He has been in practice for almost 20 years. He has a general practice, but with a special focus on matrimonial matters, general civil litigation, and also the administration of estates. Thank you so much for joining us today.
You're welcome. Thank you.
Mahmood, let's start out with formalities. What are the formalities for concluding a civil marriage in South Africa?
There actually aren't very many formalities. The only legal requirement is that the marriage has to be solemnized by somebody who is a qualified marriage officer. Now, to be a marriage officer, there's two categories. One are those people that ex officio, they are automatically marriage officers, for example, a magistrate or a justice of the peace. And then you have other people who sometimes are affiliated to some kind of a religious body. We have lots of ulama as well who have also now applied for the status as marriage officers, and they basically have now been given this by the Minister of Home Affairs. So the only formality is that firstly, the marriage must be done by the marriage officer, and secondly, the marriage will be done in the presence of two witnesses. So what happens, an appointment is made with the marriage officer. One would have to take with you your identity document, and obviously take your witnesses, who must be competent witnesses in terms of the law, in other words, over the age of 14. The marriage officer will then make an entry into the marriage register, and simultaneously he'll also give the parties a marriage certificate, and that would then be the only real formality that is required. And obviously when you do go to the marriage officer, there's certain words like, one say, do you accept so-and-so as your wife, but there's just certain prescribed words that the marriage officer pronounces, and thereafter the marriage is then regarded as being finalized.
Okay. Mahmood, on that point, where you say members of the ulama have become or been interested in becoming marriage officers or have become marriage officers, would a nikah that they have presided over then be considered a civil marriage?
No, it will not be. There is a difference between an Islamic marriage and a civil marriage. So if there is an alim who is performing the nikah, if he is also a marriage officer, then the parties would have to specifically request that he also marry them in terms of the civil law.
Okay. There are some restrictions on entering into a civil marriage. Let's briefly just look at those.
Well, in terms of people that you can marry, well, in the old days, same-sex marriages were not allowed. Today, unfortunately, that is allowed in terms of the Civil Union Act. The law also prescribes the age at which a person can get married. Today, from a legal point of view, people attain the age of majority at the age of 18. However, in terms of that age pertaining to marriage, girls who are under the age of 15 would require ministerial consent to get married, and boys under the age of 18 who require ministerial consent to get married. This means that they need to apply to the Minister of Home Affairs to allow them to get married. If a girl is beyond the age of 15, then she only requires the consent of her parents or her guardian. And the same would apply to boys above the age of 18. At the age of 18. then also, in terms of the law, there are certain degrees of people with whom one cannot get married. One cannot get married to an ascendant or a descendant. So, for example, a father cannot get married to his daughter, and also a brother cannot get married to a sister. Then there's also some degrees of affinity in terms of in-laws and uncles and aunts. That also is a probative degree of relationship to allow a person to get married.
Yes, without getting into the technicalities of it, there's also the issue of contractual capacity, a person being of sound mind and able to understand the consequences of their actions. Obviously, if you can't, you wouldn't be able to enter into a valid
Absolutely.
marriage contract.
I mean, a marriage is in essence a contract between two parties. The parties must have the same intention, that is to be married to each other, because from there a person needs to understand that flowing from a marriage there'll be other issues that arise. They'll develop mutual and reciprocal duties of obligation and support. And also when the children are born, they would each also have responsibilities towards the children. So you're quite correct. There certainly is the requirement that the parties must have the intention to get married.
Now, there are three marital regimes that can apply to a civil marriage. The automatic in community of property, then there's out of community of property with accrual, and then out of community of property without accrual. I think this is of particular significance for the viewers to understand what each marital regime, what the consequences of each regime are. Let's start out with marriages in community of property.
Okay, now, like you said correctly, the thing is, if you go to a marriage officer and if you simply tell him that you want to get married, that marriage is automatically going to be registered as being one in community of property. So people need to understand that getting married in community of property has got various legal consequences. The most important is that when parties get married in terms of this regime, there is an amalgamation of their estates. So what happens is that all assets and all liabilities that the wife has and the husband has are put into one pot, and they both then have an equal right to both those assets and the liabilities. Now, it's also important to understand that from an Islamic point of view, the marriage in community of property doesn't strictly accord with the principles of Sharia, because Sharia actually calls for a separation of the estates of the husband and the wife. So if you choose this particular matrimonial regime, it will have consequences which firstly are contrary to Islamic principle, and secondly, it also has got consequences upon the divorce, because it could perhaps happen, for example, that the husband has been the sole breadwinner throughout the marriage, and the wife has been at home. Obviously, she's also played her role in terms of caring for the household, in terms of caring for the children. She's also contributed, albeit not from a material financial point of view, but she's contributed in other ways. So on the termination of that marriage, whether it's going to be by death or by divorce, the wife will be entitled to half of the estate. And she'll also be liable for half of the liabilities, in that particular estate. So it can have very far-reaching consequences. And the other impact as well of importance is that from a law of inheritance, the law of succession point of view, if you are married in community of property, in terms of the law, you in fact only own half of the estate. So which means that if you make a will, that will only revolve around your half share. Now, again, from a Sharia point of view, in terms of being able to make a will, it may not strictly enable you to do so by reason of the consequence of the marriage in community of property. So people must be very, very cautious before they basically choose the matrimonial regime. Especially those people that want to be Sharia compliant, it is even more important that they first take advice from a legal person as well as from an alim to decide which is going to be the most appropriate matrimonial regime.
Thank you, Mahmood. We'll be back after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease. We are continuing with our discussion on marital regimes, and I've got Mahmood Mia with me in the studios. Mahmood, before we go on to the next two regimes, let's discuss the part of the regime that's going to make it different, and that's the antenuptial contract. Antenuptial contracts have to be entered into in a very specific way at very specific times, and for that reason and these requirements are crucially important. Let's look at some of those requirements.
Yes, like you said, an anti-nuptial contract means that the first requirement is that it is done ante the nuptial, which is before the marriage. Now, an anti-nuptial contract is a notarial document. It consists of an agreement between the parties. Now, we'll talk shortly about an ANC contract that includes the accrual system and one that excludes the accrual system. But just in terms of the ANC contract, the parties can by and large incorporate any term that they want into the anti-nuptial contract. But the purpose of the ANC contract is primarily to exclude the in-community. So the contract will provide, one, that the parties agree that they are excluding, the sharing of profits and losses, and the one party waives any claim against the other party's assets. So that's primarily the purpose of an anti-nuptial contract. It's to create a separation of the estates between the husband and the wife. Now, to enter into the contract, you need to make an appointment with an attorney who is a notary, or alternatively, he will then appoint a notary on your behalf. A contract is then prepared. The document has to be signed before the notary public, who will then give you a letter. So when you go to the marriage officer to get married, you must give him that confirmatory letter to confirm that you've entered into an anti-nuptial contract, because when the marriage officer has it sent to Pretoria for registration, then they will record that your marriage is one excluding community of property and one that has been concluded by virtue of an anti-nuptial contract. Now, in terms of the provisions, it's quite far-reaching. One could make some provision, for example, to say that upon the marriage being terminated by death or divorce, that the husband would give the wife a certain payment, for example, or even vice versa for that matter. So one can regulate various aspects. Now, from a Sharia point of view as well, there are some contentious things which a person can put into the anti-nuptial contract. For example, the taking of a second wife. In some ANC contexts, one can make a provision to say that the husband agrees that he will not take a second wife without the consent of his first wife. So that is a provision which one could put into it. Then secondly, in terms of, from the Islamic point of view, with specific reference to talaq, it is possible that the husband can delegate his power to the wife, but not necessarily to the wife, perhaps to a third party, to say that if the wife is in the regime and if there are circumstances which warrant her asking for a divorce, that person can then pronounce the divorce on behalf of the wife. Now, obviously, these are issues which are primarily of a Shariat. I am not an expert in Shariat by any means, but these are issues which people will have to face, because otherwise you have a simple, straightforward ANC contract which simply creates a division of the estates, and it actually excludes claims between the parties.
Coming back to that point, Mahmood, what is the status of an anti-nuptial contract? Is it, can it be taken to court? Would it be as valid as any other contract? So why I'm asking this question is, so where there are clauses which are contrary to Sharia, for example, how would those be viewed in the eyes of the law?
Well, in essence, an ANC contract is a contract between two parties, so it is binding inter partes, so which means that whatever the parties agree upon, they will be able to enforce in a court of law. So if a specific provision is made, and if there's non-abidance by that provision, the aggrieved party can then seek redress through the court.
Which really just emphasizes how important the document is and how parties should really consider very carefully what they put into it.
Absolutely. Now, the other one aspect is that you can have an anti-nuptial contract either including the accrual system or excluding the accrual system. Now, excluding means that there's a total separation of the assets of the parties, and neither party has got any claim against the other. Now, if you speak of an accrual, the accrual system is a system which was introduced very specific to South Africa, where there was some kind of a community of property attached to the ANC. So the effect of a marriage with an anti-nuptial contract, including the accrual system, is that at the end of the marriage, either by death or divorce, a calculation is made regarding the two parties' estates. So in the party's estate that has got the higher accrual, that party will then be obliged to give half the value of the accrual to the other party. So it's an effective means of allowing parties who both contribute during a marriage to share equally the spoils at the end of the marriage. Because normally it happens that, especially in today's day and age where most husbands and wives are both working, it means that whatever they've acquired up to the stage of the marriage, that is protected and belongs to them exclusively, but what they acquire jointly, then that they are prepared to share with each other.
All right.
Now, it's also important to understand that, this document must be done properly because it gets registered at the deeds office, and people must understand that, if they want to go this particular route, that's important to take good advice to also find out what other kind of provisions can be put into it. As I said, it is a contract inter partes, and one can by and large regulate any affair between the parties, in this particular respect.
Mahmood, for parties that are already married and may, for example, already have a marriage that's in community of property automatically in terms of the Act, and they now want to change and have an ANC and go out of community of property, what is the procedure that needs to be followed?
Well, this is going to entail doing a formal application to the High Court. It's quite an involved application. So one makes a formal application to court, giving the court reasons why you want to change your matrimonial regime, and there must be good sound reason for that. There's also the requirement that one would have to give a notice to the registrar of deeds, because if there is property, the change of regime is going to have an impact on the party's property. One would also then be required as part of that application to give notice to all of your creditors, and this would also entail giving physical notice to all of your creditors, and also inserting 2 adverts in 2 newspapers advertising the fact that you want to change your matrimonial regime, and that if there are any third parties that may be affected thereby, that they can then basically lay any kind of objection. So once you've complied with all of these requirements, the matter then comes before the court, and if the court is satisfied that there is sound reason for the change, and if the court is satisfied that it's not going to be to the adverse effect to any third parties, the court will then allow it. Now, as part of the process as well, one with your application submits the proposed ANC contract that you want to enter into. So once the court grants the order, then that particular contract is then registered at the deeds office, and then automatically your regime will be changed from one in community of property to one out of community of property. Now, this, obviously, to bring the application, it's quite expensive because of all the advertisements and so forth that one has to do. So therefore, it's, again, just as a matter of caution, that before people get married, it's always advisable to learn exactly what is the consequence of each of these particular regimes, and then to obviously choose it appropriately.
Over the last few years, there's been an increase in the number of fraudulent marriages that people suddenly find registered against their names. And to assist with individuals being able to verify their marital status, the Department of Home Affairs has set up an SMS verification service as well as an online verification service so that people can check whether there is a marriage that is registered against their name. If you want to do this, you require a South African ID number, and you SMS the letter M to the number 32551, and an SMS will be sent to you confirming your marital status. Otherwise, you can log on to the Department of Home Affairs website and use the online verification service. We'll be back after the break when we'll be talking about the status of Islamic marriages in the South African civil law. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease, where I'm discussing marital law with Mahmood Mia. Mahmood, now that we've looked at South African civil marriages, let's look at the status of Islamic marriages in South African law. There is an option for people to obviously do both, to comply with a Sharia marriage and then to also register a civil marriage. But where they haven't chosen to register a civil marriage, what is the status of their Islamic marriage?
Historically in South Africa, there was no recognition given to Islamic marriages because they were regarded as being what they call potentially polygamous. And on that ground, the marriage was not recognized. However, with the coming of our constitution, there was a recognition given to marriages that were concluded in terms of religious laws. Now, presently in South Africa, there's been leaps and bounds in terms of our common law where our highest courts have basically recognized Islamic marriages. Now, people must understand, however, that it is only recognized for certain specific purposes. They will recognize people as being husband and wife. So, for example, with specific reference, if there's an accident claim and a husband dies, the wife will be regarded as being somebody who's lost support, and she can bring a claim in terms of the road accident fund. From the point of view of succession, if there is an Islamic marriage, the law will recognize her as being an inheritor in a husband's estate. But it is not something which happens automatically. So, there's also now the issue where the government wants to pass, there is a bill before Parliament right now where there is the prospect of giving full recognition to Islamic marriages. That process is still in the form of a bill because there's been lots of opposition to it, the primary reason being that the bill doesn't accord strictly with Sharia principles. The argument is that our Islam is pristine, our system is pristine, so if they want to give recognition to our marriages, then they must give it full recognition without there being any kind of infiltration from other laws. So because there is that particular potential at this moment in time, that bill is still now under consideration. But I still think that it's very important that even if people are married only by Islamic rights, that it's important to get married by way of a civil marriage as well. The effect of a civil marriage is that it entrenches the rights of both parties. It creates a relationship between them which is fully recognized by the law. And I think that of importance, unfortunately, sometimes your choice of marriage only becomes of relevance when the marriage ends. But by that time, if you're only married by Islamic rights and not in terms of the civil law, then you could find yourself in a bit of a predicament. Especially in those relationships where the wife has played a very important role by taking care of the household and the children, and after many, many years of marriage, they now get divorced, and because the husband has kept all of the assets in his name, she's now left, destitute. There is certain recourse open to her, but that recourse would have to be exercised by going to the court to bring court applications and issuing legal actions, which could be which could take a long period of time, and of more significance, it can be a very, very expensive procedure. So I think it's always better to be cautious. So my advice is that if you only married Islamically, have that supplemented by getting married in terms of the civil law. You can then draw an ANC contract, which then accords strictly with the Sharia position. Or before you enter into the marriage, you can have a discussion between spouses to decide whether you want to have any kind of shuffling in terms of the assets so that there can be an allocation done to each party. So on that basis, there is equity, there's parity, and then hopefully they'll be able to live happily ever after.
Mahmood, another difficult issue in our law is the issue of polygamy, which has really been frowned upon in the past, but I think considering the status of our president, there's been a little bit of a change in that regard. What is the position of polygamy currently in South Africa, and also what are the rights attached to wives that are part of a polygamous marriage?
The basic principle is that South African law does not recognize polygamy. However, as I said, because of the constitutional developments, there is some recognition in this particular regard where people take second wives because in terms of Islamic Shariat, they're entitled to do that. Now, there has been some case law as well where the courts have afforded rights to the second wife as well. And this is basically in recognition of the constitutional rights that that wife has. Now, it's not something which is very easy. So I think also, in those cases where people do have more than one wife, I think it's important as well that if they are making a will, the law would allow them to then obviously make provision for both of the wives. So in this way here, it avoids conflict. Now I understand that it isn't always a very easy situation to deal with these kind of matters, but it is something that if people want to enter into, they must think about it carefully, and then they must make sure that they enter into the appropriate wills and so forth to ensure that the marriages are actually covered.
Excellent. Mahmood, I think that's really crucial information for our viewers to understand. Most of us will have entered into Islamic marriages, and to understand how the interface is between that, the Sharia, and the civil law is really important. And I think it's important for our viewers to understand that it's not the end of the road, that they can still make adjustments to whatever regime or type of marriage that they currently have entered into. And also for those who are thinking of getting married, to really pay closer attention to how they would want their future to be governed. let's just lastly look at what would be void or voidable marriages.
Yes. Now, the thing is, one must distinguish as to what is a void marriage and what is one that is voidable. A void marriage is one where even if the parties get married, that marriage will not be recognized by the laws, which means that there is no marriage from the very inception. So, for example, if a person is married by somebody who is not a marriage officer, that will be a void marriage. So, even if the people believe that they are married, there won't be any marriage. Now, there is the issue of what they call a putative marriage, but that is something which obviously it doesn't really fall within the ambit of our discussion. Another factor which could render a marriage void is where there is a person who is of minor age, and if that person gets married without the requisite consent of either the parent or guardian, or in the case where there was ministerial consent required, where that is not obtained. That will also be regarded as being a void marriage. Also, if a marriage, you also announced earlier regarding the issue of fraud. Today, this is happening very often where people are being married without them even knowing. So in such a case, because that marriage was concluded by fraud, that would be a void marriage. Now, voidable marriage is something where there is a marriage, but the status is something which will be pronounced upon by the court, and that will depend upon the circumstances. So to use, again, the example of a minor, if a minor gets married without the parental consent, but subsequently obtains it, then that voidable marriage will become a legally recognized marriage. Other instances of ways, voidable as well, is where a person gets married to an insane person. So that as well, it can happen that at that moment in time the person's state of mind was something, but later on if it improves or changes, then certainly that marriage can also be then sanctioned by the court. These are just basically one or two examples. But, the important aspect is that, very often people just take it for granted that because from a Sharia point of view, we can get married quite easily and without very much formality. But if they want recognition to that marriage, it's important that they look at all of the civil requirements and ensure that they actually comply with all of that. Because, a marriage is something which creates rights and obligations between the parties. And, if it's not done properly, it can have, very disastrous consequences down the line. Now, see, people also need to understand that when you get married, you're going to have certain natural consequences flowing therefrom. For example, it automatically creates a relationship between husband and wife. It creates a duty of support between husband and wife. And in law, this is a reciprocal duty. So like the husband owes a duty of support to the wife, she also owes a duty of support to him. They obviously need to give love and affection to each other. In terms of the law, they're also entitled to have a consortium between the parties. So these are all very important aspects. And if the marriage is void or voidable, it can have a very long-term effect. And the other one sad part is that very often people get married, but when the marriage ends, then only do they realize that, we've woken up too late, and now how do we sort of have this rectified? So it could happen, for example, where there isn't a marriage and the husband dies, for example, and he hasn't left a will. Now, for the wife to be regarded as being an heir in his estate in terms of interstate succession, there has to be some kind of a link, and that would be marriage in this particular instance. So it's very important, in a case like that. And also, if the marriage ends, for example, the issue of the children. How does one then deal with the issue of custody and access and so forth? So it's very important that all of these issues are borne in mind when one is concluding the marriage because, like I said earlier, unfortunately, the real import and the real consequence of a marriage sometimes only comes alive when the marriage is ending. And by that time, it could be too late or the person could then suffer very extreme circumstances.
Mahmood, it's been a pleasure having you with us in studio today. Thank you so much for taking your time to be with us.
Jazakallah for having me, and assalamu alaikum to all the viewers.
Viewers, I hope you have absorbed some of this important information, and make sure you tune into my show next week. I'm waiting for your suggestions and comments. Please email me on legalease@itvnetworks.tv. Assalamu alaikum wa rahmatullahi wa barakatuh.